Hello, I'm Barrister Garn. Welcome to Easy Law Talk by Siam Center Law Group. Today I'll explain an important law that can help many criminal cases be resolved without going to court, without imprisonment, and most importantly, without a criminal record. This law is the Mediation of Disputes Act BE 2562, 2019. The purpose of this law is to reduce the number of cases going to court, give the parties a chance to talk and reach an agreement, and promote harmony in society. There are three types of criminal cases eligible for mediation: cases that allow reconciliation, such as embezzlement, fraud, and defamation; certain petty offense cases specified by law; special cases normally not allowed reconciliation but permitted under the law, such as assault, minor theft, or reckless driving causing serious injury. However, serious crimes such as drug offenses, firearms offenses, murder, rape, or robbery cannot be mediated. The mediation process begins when the investigating officer informs the parties of their rights. If both parties agree, they enter negotiation with a neutral mediator and make a joint agreement, such as compensating damages, issuing a public apology, or withdrawing charges. If the agreement is fully performed, the case will be dismissed completely with no criminal record. If not, the dispute will return to the normal legal process. The benefits of mediation include saving time and costs, avoiding court appearances, not having a criminal record, and offering offenders, especially minor offenders, a chance to rehabilitate and start anew. That's an overview of the Mediation of Disputes Act. If you or someone you know is facing a criminal case, always consult a lawyer to make the most of mediation rights. Thanks for watching. Don't forget to subscribe to our channel to get first-hand news.